Good evening, everyone, and thank you for coming to the 2024 Wingarra Djuraliyin Growth in Thinking Public Lecture on Indigenous Peoples and the Law. My name is Elisa Arcioni. I'm the Associate Dean, Indigenous Strategy and Services of the Sydney Law School, where we are this evening. In the words as taught by Professor Jacqueline Troy, Ninani Nalawangun Maribajiri Gadi Nurada. We meet to talk together on the beautiful country of the Gadi. I acknowledge elders past and present and extend my respect to all Aboriginal and Torres Strait Islander people here tonight. To commence our proceedings this evening, may I introduce Uncle Chicka Madden, Gadigal Elder. Uncle Chicka, please come up.
Good, thank you. Good evening, folks. My name is Charles Madden, but known around the inner city of Sydney as Chicka. Now, that's a nickname that I got many, many years ago, going to Redfern Public School, which is now NCIE, the National Centre of Indigenous Excellence. Folks, I'm from Gadigal land, Aboriginal land. That's the land we're on at the moment. For many, many years, I've lived and worked around the city of Sydney. I've been involved with quite a few Aboriginal organisations over the years. I've been a director with the Aboriginal Medical Service at Redfern for over 40 years. Also a director with the Redfern Aboriginal Housing Company, Aboriginal Hostels Australia, and the Metropolitan Local Aboriginal Land Council. I've got to mention it, folks. Also a life member of the Redfern All Blacks Rugby League Football Club. Folks, for many, many years, I've lived and worked around the city of Sydney. I'd like to take this opportunity this evening to extend a warm and sincere welcome to all of my Aboriginal brothers and sisters, non-Aboriginal brothers and sisters. If we have any brothers and sisters here from the Torres Strait or further afar across the seas, welcome. Welcome to Gadigal land. The Gadigal clan is one of 29 that makes up the Eora Nation. The Eora Nation is bordered by 3 distinctive landmarks. We have the Hawkesbury River to the north, the Nepean River to the west, and the Georges River to the south. Those 3 rivers form the boundaries of the Eora Nation. Folks, if you've travelled across this great city of ours today, the state, or this great country, or from afar, welcome. Welcome to Gadigal land. Enjoy your stay. Have a safe and trouble-free trip home. Once again, welcome, welcome, welcome. Enjoy the evening, folks. Thank you.
Thank you, Uncle Charles, for that welcome to country. My name is Rita Shackel, and I'm the interim head and dean of the Sydney Law School. I'm absolutely delighted to welcome you all to this 2024 public lecture on Indigenous peoples and law. I will briefly introduce each of the speakers and the participants in the public lecture tonight, and then I will hand over to our Professor of Practice, Teela Reid. I'm particularly pleased to welcome tonight's speaker, Professor Val Napoleon, the Law Foundation Chair of Indigenous Justice and Governance at the University of Victoria, Canada. Professor Napoleon is from northeast British Columbia Treaty 8 and is a member of the Saulteaux First Nation. Professor Napoleon is also an adopted member of the Gitanyao Gitsan House of Luhorn Ganada Frog Clan. Professor Napoleon has a long relationship with the Sydney Law School and colleagues in the law school. And we very much are looking forward to building that relationship and deepening that relationship as we explore further institutional connections between our respective law schools. I would also like to acknowledge Professor Nicole Watson, who is now at UTS. As our Associate Dean of Indigenous Strategy and Services at the Sydney Law School, Nicole collaborated closely with Professor Napoleon and hosted Professor Napoleon's Indigenous Research Unit. In 2021, Nicole gave the inaugural lecture in this series entitled Indigenous Women, Outlaw Culture and the Law, a very powerful act of storytelling and scholarship. Professor Teela Reid will provide some opening remarks this evening and will provide a more formal introduction to our speaker, Professor Napoleon. Teela was recently appointed as the Sydney Law School inaugural Professor of Practice, and we're absolutely delighted, Teela, to see that appointment and to welcome you to the law school. Teela is a proud Wiradjuri, Wailwan woman, a lawyer, an essayist, storyteller, and co-founder of Blackfulla Book Club, a platform that honours First Nations ancestors as the original storytellers. Teela's practising expertise is in Aboriginal land rights, native title and cultural heritage laws. She also has a practising experience in criminal defence, stolen generations matters, as well as being a leader on the race power that culminated in the Uluru Statement from the Heart. Brendan Loizou will facilitate the Q&A session at the end of the lecture. Brendan is a Warlpiri man and belongs to a traditional owner family of Marlikka dog dreaming in Ali Karang, Central Australia. He's a member of the Sydney Indigenous Research Network and is engaged in a PhD in law here at the University of Sydney. Brendan is also a barrister and a member of the New South Wales Bar Association. Marlikka Perdrisat will give the vote of thanks. Marlikka is a Nyikina Warrwa and Wangkumara Bar, and I knew I was going to get this wrong, and I do apologise, Marlikka, despite all of the tuition you gave me. Marlikka is the inaugural Aboriginal and Torres Strait Islander postgraduate fellow within the law school and is undertaking a PhD in the law school. Before I hand over to you, Teela, I would also like to take this opportunity to thank Associate Professor Elissa Arcioni, who has been a very active, very committed Associate Dean of Indigenous Strategy and Services and has been a driving force in the organisation of this lecture tonight, as well as several other associated events that we've held at the law school this week. So thank you, Elissa. And now it is with great pleasure that I hand over to the Sydney Law School's Professor of Practice, Teela Reid, and ask Teela to give her opening remarks and a more fulsome introduction to tonight's speaker, Professor Val Napoleon.
Uncle Chicka, thank you for your welcome to country. I honour your ancestors. I thank your people for caring for and sustaining this country since time immemorial. And I acknowledge that First Nation sovereignty across this continent has never been ceded. I'd also like to thank each and every one of you for showing up in this room. I know everyone is very busy. There's lawyers, there's judges, there's barristers, there's my titters who show up to so many events. And indeed, this kind of change takes an entire community. I'd like to thank Chalk and Brant as well, who have been my home of practice for some time. Louise Mallon, I know G&T are here represented as well. And last but not least, Judge Sophia Beckett, thank you for getting me through my law degree. Most importantly, it is with great pleasure that I have the privilege of introducing our very special guest speaker, Professor Val Napoleon, who joins us from Vancouver Island in Canada, where the University of Victoria is located on the lands of the Coast Salish people. I had the pleasure of visiting Professor Napoleon on Turtle Island in 2022 in my role as the inaugural First Nations practitioner in residence at Sydney Law School. And in 2023, Professor Napoleon came to Australia. During her formal visit and commitments here, I took Professor Napoleon to Redfern to visit the Wayanga elders, which was also at the time leading into the Indigenous voice referendum. The connection was brief, but an important one. Making contact with elders and building relationships beyond the walls of these institutions is critical in our pursuit to cultivate justice and share our stories. In fact, over 15 years ago, I lived on Vancouver Island and completed the final year of my undergraduate degree at UVic. At that time, it occurred to me there were many significant differences in teaching methodologies, which made my learning experience so much richer. We sat in circles, we shared stories, we were able to quote and footnote elders' oral testimonies as leading authorities. We were encouraged to bring our whole selves to class and to test the boundaries of our own limiting beliefs and how we imagined the world and the impact we wanted to have. Most of all, we were encouraged to challenge the status quo and to situate our lives in the context of the history of laws and policies that shaped colonisation in Canada. For example, I recall a class on the Canadian residential school system where we sat with elders who told their stories. Both Indigenous and non-Indigenous students were challenged to not strive just for the best grades, but to be better humans, to utilise our skills to seek justice and to leave a legacy worth living for. I have been back to several times to Turtle Island, and on my most recent occasion in 22, when Professor Napoleon was the acting Dean of Law at UVic, I witnessed the opening of the Law School Assembly. Immediately, students are welcomed to the law school by a local elder. They introduced the profession. There is a First Nations Law Students Society, and most powerfully, students were directly told of their responsibilities as lawyers. Started that day as they entered law school, and the privileges that came with understanding a Western system of laws. They were confronted on their first day with the truth that this understanding of Western laws must be read in the context of its implications of First Nations peoples, and were reminded of the Canadian Truth and Reconciliation Commission. This knowledge was embedded from the outset in an authentic way, and while the room was silent as Professor Napoleon gave her opening address, I could hear students thinking. There was not a laptop or a mobile phone in sight, and I do have photo evidence of this. I also met with some of the first graduates of the world first Juris Doctor in Indigenous law, and while it was incredibly inspiring, I was not surprised that this program is the brainchild of UVic law, such as Professor Napoleon and Professor John Burrows, to name a few. I also caught up with a past dean of this law school, Canadian Professor Jeremy Weber, who kindly took me on a short tour of the island I had not seen before and told me of local stories from the coastline where you could see across the water to the snow-capped mountains into the United States. What struck me and stuck with me were the many small conversations I had with me that day. We exchanged the stories and offered deep reflection as critical skills to continuing to do this work. Professor Napoleon and I shared stories of our families. I spoke of my matriarchal kinship, especially my nan as a healer, storyteller, and keeper of our children, a decision maker. I shared how my nan is a medicine woman. When she is on Wiradjuri country, she knows exactly what bushes are blooming. Professor Napoleon looked at me and said, well, your nan is a legal agent. She is someone of authority. Our elders are legal agents of authority. They may not be in positions of judges or barristers or lawyers, but they are critical in maintaining our Indigenous legal orders. I am so thrilled Professor Napoleon and your grandson could join us here this evening. I have asked Professor Napoleon how she started her journey on building the Indigenous Law Research Centre at UVic, and in her quick and gracious style, she replied, well, we just decided one day to stick a sign out the door and call it the Indigenous Law Centre. Sounded so simple, I thought. She also reminded me of the importance of building a team of supportive First Nations people around you in this work. And it is so clear to me that during my time at UVic, the respect each First Nations member has for each other's work, the goal is greater than the individual pursuits. In March 2025, Professor Napoleon at UVic will formally open the National Centre for Indigenous Laws in Canada. From that very small sign on the door, Professor Napoleon has acquired $13 million from the BC government, $9.1 million from the Canadian government, $5 million from the Law Foundation of BC to establish the world's first National Centre of Indigenous Laws, and is in the process of raising an additional $50 million. In speaking about the importance of what the National Centre for Indigenous Laws mean at UVic, Professor Napoleon said this, and I quote, "The process of human beings working together in a way that builds on the civility of a society, that is the very root of what law is," end quote. So Professor Napoleon is the Foundation Chair of Indigenous Justice and Governance. She is from the Northeast British Columbia Treaty 8, a Cree woman adopted into the Gitxsan tribe. Prior to joining the Faculty of Law at UVic in 2012, she was cross-appointed in the Faculties of Native Studies and Law at the University of Alberta. In one of many conversations with Professor Napoleon, as I contemplated the impact I might seek to make in this profession, her wisest pieces of advice to me was this, and I quote, "We live in a world we imagine exists." And to Professor Napoleon, I say to you, Yinjamara Wanangana, which means in Wiradjuri language, my language, the wisdom to live with respect in a world worth living in. Everyone, please join me in welcoming Professor Napoleon to impart her wisdom.
I don't know about you, but after I get a wonderful introduction like that, I always feel a little bit incompetent, but I'm so honored. Thank you for the welcome to country. And thank you to the generous and hardworking souls who made this visit possible, to Elise and to others here. It's really an honor. And the biggest thanks to my grandson, Elijah, almost 11, who accompanied me to keep me on the straight and narrow with my visit. So thank you for coming. Thank you for sharing your time. So a long time ago, one of the elderly Giksan, Fred Johnson, whose Giksan name was Lelt, he talked about Giksan law at one time had been reduced to a small light. And over time, that light was going to get brighter and brighter, and it was going to grow. And so I imagine he was talking about a light, something like what you see on the screen behind me. So these photographs are mine. They're taken on a little mountain called Picols, just right in Victoria. And I was told a long time ago that people listen better if they have something to look at. So just in case your mind wanders, it's okay. There's things here. And these particular pictures you'll see roots that are twisted and branches that are twisted, broken trees, and they represent, for me, the history that our legal traditions have withstood. So we haven't come through all of that history entirely intact, but we're still here, and Indigenous laws are still here, and Indigenous legal orders are still here, despite colonialism. So there's been challenges, there's been denials, and sometimes there's been distortions, but there's still change, and there's resilience, and there's strength, and that's what we have. So Indigenous peoples with Indigenous laws are continuing to find our way. We're continuing to, wherever there's been a bit of space, there's Indigenous people acting on obligations to one another wherever they can. And so they haven't gone away, but there's work that has to go on everywhere to restate, to rebuild, and to restore Indigenous legal orders and all of what that means for our collective lives. So what I'd like to do in this talk is to take up the question of what happens when we reimagine legal rulings and replace those state processes or other processes with a practical application of Indigenous law. And I know that people like Nicole Watson and others have been reimagining major legal decisions as well. And it's a part of finding a way to recognize law's work in the actual lives of real people with issues that matter. And Indigenous law has to solve problems, and it has to matter as well. So to do this requires us to focus on legal perspectives, on principles, on practices, and these are necessary to reason through really hard and complex problems that all of our communities are grappling with. They arise with any legal order, any system of law. So this centering of Indigenous legal decision-making points to the importance of intersocietal legal capacities within and across legal orders, but also beyond our own legal orders to look at what are the interactions with other peoples and with the state. So my intention is to support ways of understanding and working substantively with Indigenous laws through these reimagined processes, and also through direct application and different decision-making. So I'm going to take 3 Canadian examples and rework them with different legal orders. The first is a decision that was made by the Commission of the Canadian Energy Regulators concerning a section of land in Secwepemc lands that that is very sensitive and of high cultural significance. The second was a decision made by the Law Society of British Columbia, and it concerned the citizenship of an Indigenous woman. And the third concerns a landfill site in Manitoba where the bodies of at least 2 Indigenous women were dumped by an admitted serial killer, and there was a dispute about whether to search the landfill for their bodies. So the first issue. Secwepemc means the spread out people. There are 17 communities over 145,000 square kilometers. These are Secwepemc. And these peoples, as with others, have been unrelenting in advocating for their recognition of their ownership of their lands, for them being recognized as peoples. So for example, in 1910, they submitted a memorial to the then Prime Minister, Wilfrid Laurier, and they recounted the grievances against the Canadian government and settlers for the previous 50 years and the different ways that they were on their lands. So they've been advocates and activists for a very long time. At issue here is the Trans Mountain Pipeline, which was originally built 70 years ago. It's it's described as a multiple product pipeline. It carries crude oil as well as refined products from Edmonton, Alberta to the West Coast. It's about 1,100 miles, 1,150 miles. So the expansion project was basically to double or triple the oil that was to flow through the pipeline from 300,000 barrels a day to 900,000 barrels a day. And so one of the areas that was really important for the Secwepemc people was called the Pipsil area. And Pipsil means the trout place. It holds this deep spiritual and cultural value, and it's an area that people used historically, but still use today. So there's, all of the different activities that take place on the lands, medicine harvesting, plant harvesting, and everything else. It's a transitional zone. There are grasslands, there are wetlands, there's plant biodiversity, and it's also a source of laws for the people. So one of the stories from that place is about the trout children. And what the story does is it sets out the conduct of people on the land, and it sets out the reciprocal accountability to living things on the land across generations and within generations. So the Secwepemc completed their own environmental assessment, and they set out all of the things that were in this site. There's medicines, food, incredible biodiversity. And over several years of negotiation, they consented to the pipeline going through their lands. But they said for the Pipsil area, 4.2 kilometers, there has to be minimal surface damage, and they requested that a process called microtunneling be used rather than the usual open trench approach. So Trans Mountain argued that the cost of going around was prohibitive. They argued that there were technical difficulties, the rock was too hard, and so sorry. What that's about. They reneged on the microtunneling requirement. And this went to the Commission of the Energy Regulators. And so what that commission did was they maintained the approval of microtunneling for the majority of that corridor, but they allowed open trench mine construction for a portion of it. The kinds of provisos that were attached were, they had to make sure they didn't go through burial areas. They had to minimize surface destruction. They had to restore lands, and they had to compensate the Secwepemc peoples. So at the end of the day, what the commission found was that despite all the arguments that the Secwepemc people put forward, that about the profound cultural impacts that this would have, they said that their accommodation within Canadian law of the rights of Secwepemc people was appropriate. So they held that decision. So let's switch it up here. Now, imagine that you're working with the Shuswap Nation Tribal Council and with the Elders Council. Imagine that you've been asked to prepare an opinion about the Pipsil area issue, and you've been asked to make sure that what you do is you draw on Secwepemc law and legal precedent. And the legal issue is, how do people within the Secwepemc legal traditions respond to a conflict about Secwepemc lands with another people? In addition to that, what the analysis requires is that you look at what relationships, responsibilities, and rights do people have within the Secwepemc legal traditions to land, to animals, to water, and to plants. So that would be your assignment. You've been directed to the Indigenous Law Research Unit resources that have been developed in partnership with Secwepemc peoples. There's a land and resources casebook, a report. There are citizenship materials. So all of this, as well as other things, would be part of your research materials. So you have that to work with. In going through this, what you'll see is that the lands report introduces 6 Secwepemc principles, which are described as the underlying constructs for legal decision-making. So first, the stories and the community witnesses tell us that humans are able to influence the environment. They can productively engage with that environment, but they can also harm it through that engagement. The second is that law existed as a guiding force in Secwepemc society, and law has changed over time and will continue to change, but the integrity of that law has to be upheld, and including the responsibilities to the land. Third, while Secwepemc legal principles can be learned in English, there's a deeper and richer meaning of what the laws mean if it's in Secwepemctsín, in the language of the Secwepemc. Fourth, law accepts that people have the freedom, individually and collectively as agents, to make their own choices, and these can be good or bad. You have to then deal with whatever those are. And fifth, the relations of respect between peoples, different peoples, within peoples, and with the land. That is the way to learn about living with Secwepemc law. And lastly, land always presents challenges. And so while people can manage, there's the dangers and the challenges of land doesn't go away. It's a constant part of life. So part of what you start to see is that the first principle acknowledges the ability of humans to productively change or to harm the environment. But they don't say that there's thought and care and consequences that surround these different kinds of decisions. Because what's really important is to not harm the land, which means you have to have a conversation about what does that mean? What does harm mean in this situation? And for some Secwepemc peoples, the open trench pipeline was a harm. because of the way that it interfered with the animals and everything else. So critical here is that those discussions, those interrogations of experiences and perspectives, and to look at what are the consequences and then what are the potential strategies for dealing with those. Secwepemc territorial legal practices require that what you do is respect other people's legal authority and integrity. So the recognition that all peoples have those, and that the relationships, part of establishing relationships is through ceremonies, through gifts, through public feasting, through witnessing. And there's another requirement of people following through on agreements. So recall that the Secwepemc initially agreed to the pipeline with a proviso that it be protected. And that was what was at issue. So the whole question of what happens with Secwepemc legal authority according to their laws, according to where did that go in the interactions with the Trans Mountain? So the recognition of one's laws is a recognition of people's ability to be governing, to be self-governing and self-determining. And that is one of the keys that was missing in the original relationship with Trans Mountain. The other kinds of legal narratives require that if you have a conflict, you have to solve the conflict. And you have to seek ways for people to be able to live together. And the word that they use is with happiness. So but when you're on a people's territories, you're required to be deferential to those laws, to those knowledges, and to those practices. And similarly, when Secwepemc are on other people's lands, they have to show that same kind of deference. So these are all part of the legal practices that people know and understand. So in face of that, what could Trans Mountain argue? They could argue that they were deferential to the Secwepemc because they had a mutual benefits agreement, that there were consultations, that there was inclusion of the Secwepemc as plaintiffs in the commission's hearing and in the decision. But the law that applied was solely Canadian. There was no consideration of Secwepemc laws or Secwepemc legal processes or the requirements to establish the kinds of relationships that are necessary between peoples. So a lawful Secwepemc response would at the very least have required deference to the substantive and procedural Secwepemc law that was outlined in the materials that people had so carefully put together. There was also a requirement for as broad consultation as possible, and rather than acting in isolation from the community. So those different kinds of legal processes and inclusion of different decision-making in the different negotiations, they fell far short of the kind of iterative family consultations that would have made that a legal process according to Secwepemc law. So had the decision been made according to Secwepemc law with all of the processes and consideration of the principles and the consequences of human behavior, the exploration of harm, had all of that gone on, the Secwepemc may have reached the same decision as the Canadian energy regulators. But they could also, depending on the legitimacies and the precedent and so on, made a different decision, which would also have been lawful. And I say that because the decision at the end of the day was close, and there's always an arc of argument within the precedents. But, what would have the difference between following a Secwepemc process as opposed to ignoring Secwepemc law was about maintaining the integrity of the Secwepemc legal traditions, as well as a healthy relationship between Indigenous peoples and Canada. So, in thinking about this particular issue, there are some Canadian judges who have recognized that Indigenous law is also the law of the land, a law of Canada. And so had that been fully considered, had all of that been a part of that process, rather than thinking about Secwepemc people as being outside the public interest, there was an opportunity to do something far greater, far more important than what actually happened. So it's complicated. It would have taken longer, but it's not impossible. It was all actually doable, and people had done the homework in order to be able to support an alternative process. So turning to the second really thorny issue. So this is citizenship, Indigenous citizenship. In 2022, the Canadian Broadcasting Company, the CBC, published several articles in which they argued that one of the leading scholars, activists, Indigenous woman, Mary Ellen Turpel-Lafond, she was a high-profile Indigenous leader and someone who'd been very in the public eye. They challenged her identity as an Indigenous person, and they challenged her family history and all of her credentials. So that challenge and those news articles caused major upheavals across the country. And everybody weighed in. Everybody had an opinion. Most of it was damaging. Most of it was really negative. And in that public dichotomy, those that were supportive of Turpel-Lafond were quieter, and at least one of those people even got death threats. That's the extent of of feeling that and anger that was around this decision or this expose. So what we saw was, national lateral violence, and the consequences for Turpel-Lafond were extensive. So she lost, she had 11 honorary doctorates. 4 universities rescinded those, and then the other 7 she voluntarily gave up. She asked to be removed from the Order of Canada, for which she had been awarded several years earlier. And when you look at all of what was going on and the cries of outrage and the cries for more blood, the amazing lists, what's lost is that why she received that recognition. She was honored because she was an extraordinary champion of children, of the vulnerable. She worked in health, she worked in child protection. She made real changes to policy and to legislation. She was a former provincial court judge, as well as a practitioner and an educator. So that was the work she had done. She didn't receive the 11 honorary doctorates simply for being an Indigenous woman. So that was lost in the public debate. So there's now what we see an increased form of public vigilantism that takes place in our universities, targeting Indigenous faculty, Indigenous staff. So there's no denying that the whole issue of fraudulent identity it's real, and there are consequences for it. But there's questions we need to ask about how and who gets to decide these different issues. And so when we look at it, it's not a matter of Indigenous identity. What it is a matter of Indigenous citizenship. It's a matter of governance and it's a matter of law. So discussions of identity and citizenship, they have to be deliberated within those larger frameworks that by which people govern themselves. And there has to be specificity in that examination of the issues within those frameworks so that there's, from whether you're Cree or whether you're Gitxsan, you're looking at something that is coherent and you're able to reason through the issues. So if you were Gitxsan, if you were, thinking about how do you determine being Gitxsan, there has to be, you turn to Gitxsan precedent, you turn to authoritative decision makers, you turn to legal processes, to substantive and procedural rights, to legal obligations, and to guiding legal principles, as you would with any other legal issue. And those processes and those resources then have to inform like a reasoned response that will hold legitimacy in the face of the contestation. And that has to be a formal process. And it has to be witnessed so that it creates further precedent. So a legal process is not simply making declarations, and it's not simply assertions of outrage or assertions of what law is. There has to be much more to it. And what occurred was not a legal process. So there are lots of examples of historic Indigenous citizenship practices. So with Gitxsan, you're born into your mother's house. There are laws that manage how people in a kinship unit, a matrilineal kinship unit, connects to land. There are processes for bringing people in for different reasons, including population numbers and marriage, and for political ties. Again, there's ways to conduct and make those decisions. For Secwepemc people, one of the biggest projects that we worked with the Indigenous Law Research Unit was determining Queselton with the Secwepemc, which is how do people belong? And the three questions that they said you had to ask when you're thinking about citizenship are, how does one become kin? And the second is, if you are kin, what are your responsibilities, your obligations? And three is, what's the legal response if you fail to live up to your obligations and your failure causes harm? So there's laws and processes around the Secwepemc. For Cree, you're born into your family, but there are also adoption and inclusion laws and ways to establish relationships between communities. What matters for the Cree is that you have a continuing obligation to ensure inclusion and public responsibilities and fairness in that process. And for the Daniza, as another example, these are peoples from different linguistic groups in different parts of the country. There's laws for bringing in people. And what's really important is that when you have children of mixed heritage, that those children belong to both peoples, that they're always included, and that's the priority for the kinds of decisions that are made. So there's intersocietal relations. They're about ensuring safety and well-being in the larger communities. And, in one of the reports that I did with the Daniza law, and I looked at over 100 narratives, looking at how do people live together across difference was the question. And so, the two of the propositions were that upon investigation and deliberation, if there is incompatibility with another people, but no continuing danger, there's a responsibility to negotiate how to live separately. If, on the other hand, upon investigation and deliberation, if there is incompatibility combined with a danger, then you have an obligation to find ways to protect your family and your group. So these practices our peoples have always had, and they're very different than the kind of the ways that Mary Ellen or other people who've been challenged have been dealt with in terms of the declarations. So part of the difficulty has been that we have the Indian Act, which has imposed, centralized systems of decision-making without thinking through what the consequences of those are. And that has contributed to much of the disruption and confusion that some people are still dealing with. So if we look again at Mary Ellen Turpel-Lafond, there's two legal issues. One is, was her father Cree, as she claimed, and she said he was adopted from a Cree family. So there was no legal process to look at that, no Cree legal process to look at that question. And the second was the community that she married into 30 years previous had claimed her, said that she was a part of their community. But that wasn't considered in what we saw in terms of the public trial, the national public trial that she was subjected to. And then the most recent thing is that the Law Society of British Columbia got involved because there was a complaint made about Mary Ellen based on her identity. And the discipline committee only accepted her as an Indigenous person after she did a DNA test. So the laws, the Cree citizenship laws, weren't considered in her case. What was considered instead was a DNA test founded on a notion that citizenship is something that can be, is biologically determined. So the authority to determine her citizenship was her communities, not the courts, not the law societies, not the universities, or the court of public opinion. So, but it's returning those issues and supporting communities to be able to take those up. That's the work, part of the work that has to be done. I just want to make sure I don't go over time. Okay. The last issue is a bit shorter. It's a harder one. So in all of the different legal orders that we worked with, one thing that came through consistently across the country is that when you have a decision to make, you have a responsibility to make that decision to the best of your ability. And if you don't have the information to do that, you have to go and get it. You have to investigate. You have to make sure you get the evidence. And the people that need to be a part of that decision are there. So in 2022, the Winnipeg Police Service informed the families of 2 Indigenous women that their daughters had been victims of homicide, and their bodies had been disposed of in garbage bins, which were then taken to the landfill site outside of Winnipeg. And Jeremy Skibiki was convicted for the murder, for their deaths. And initially, the families were told that there would be no search of the landfill site due to cost, as well as due to fear about toxic exposures to the chemicals and so on. So there were massive protests. There were, it was something that touched many people for obvious reasons. It was a really hard situation. And the provincial government changed, so there's a new premier. He's the first Indigenous premier in Canada. There was a feasibility study that was conducted, and Wab Kinew, the premier, has been engaging with the families and with the communities with pipe ceremonies and in culturally respectful ways. And a search for the landfill site was started. So, well, you know, this is significant and it's really important, but none of it was framed within Cree law. So arguably, had Cree law been applied and, you know, Cree legalities and obligations could have been used to develop the terms of reference. And there also would have been a way to put the bounds around the decision that was made so that the legalities of the Indigenous peoples, the Cree peoples and Anishinaabe peoples who are there, that seeing them as lawful, contributing, engaged people in this horrific issue, that's what could have happened. And that was a missed opportunity there, but the search is going on. So Hadley Friedland, someone that I've worked with a lot, and she's established the Wahkotuwan Law and Governance Lodge at the University of Alberta. She's done a lot of work with Cree law. And again, I show you this just to show that, you know, with the different work that people have been doing, you know, you can look to Indigenous legal orders. You can start to see there's substantive and procedural rights. In Cree law, there's a right to protection and safety. There's a right to be helped if you're vulnerable or you're incapable. There are procedural rights, the right to be heard, the right to be included. These are all identifiable rights that are part of the Cree legal order. You know, the collection of evidence to make sure, again, that there's the decisions, there's principles of dignity and there's principles of safety, all of which are part of what needs to inform how those decisions are made. So, you know, Premier Wab Kinew absolutely needs to be commended for taking this positive steps in the search for these Indigenous women. But you know, again, there's more that could have been done in looking at how to recognize people in their own lawfulness as complete peoples. So, you know, to conclude, the title of this talk was about expanding the universe and to place legal decision-making at the center of issues, real issues that people and communities are experiencing. So my thesis is that resources for Indigenous law exist. They exist in lots of different places where people have had the opportunity and support to do the kind of rebuilding that's necessary. So whether it's pipelines, whether it's citizenship, whether it's criminal harms, or any other, you know, area of human concern, there are resources and there are ways to involve people. And what's really important here is that it's about moving past the way that Indigenous law has formally been talked about in previous times in terms of a lip service or in terms of a cultural artifact, and instead moving to see it as these are complete human processes for people to manage themselves today as well as in the past. So, and it's moving Indigenous law out from under the shadow of state law to be able to be a practical and productive part of human life. So it needs to be a starting place for solving problems. The last thing I want to just mention is that we've been working for a long time now in terms of working in partnership with Indigenous peoples to rebuild sector by sector areas of law. And I've mentioned several here. And these resources belong to the communities, and we share them if we're given permission by those communities to do so. And we, with that support from that research, we have the Indigenous law degree programs, the dual Indigenous and non-Indigenous law degrees. And what was mentioned earlier is that we're opening the National Center for Indigenous Laws. So we've doubled the size of the law school in order to do this. And this next project, the next 5-year project, is to look at how do we rebuild entire legal orders over a period of time, but to do so in a way that puts Indigenous people in a place of promise and abundance, rather than always having to worry about the donors and the funders' priorities. So it's looking at how do we create real opportunity and support for people without the kinds of constraints that we've been under for so many years with colonization. So the new imaginary requires that we think about what would Canada look like if our legal orders were intact and functioning and healthy, and peoples were healthy and within those. So that's the next step that we have to take up. And with that, I'm really happy to listen to your questions.
Well, that's a wonderful speech and talk, and generates, I hope, lots of questions and thoughts. First, pay my respects to Uncle, and on the land that we're all sitting here listening. And thank you again, Professor Napoleon, for such a wonderful talk, and to other members of staff, law school, and other visitors. Ashley is at the back, has a roving mic, so we'll open up the floor to questions.
Thank you, Val. Another approach to the pipeline would be to triple the flow through the pipeline, and then one day to reduce the flow to zero and just stop oil. What do you think?
So ultimately, the work of Indigenous law doesn't exist in isolation. Indigenous peoples are, the world and the challenges that we all face, including the fact that our planet is burning. Ultimately, those are the real issues, the larger picture, and everything we're doing within the micro has to connect with the micro, or the micro has to with the macro, sorry. And the people need to engage in getting to those kinds of decisions, but they're not going to happen just in separate little parts. There has to be ways to connect it.
So my name is Yana Svetiev. I'm here from the Sydney Law School. And I guess I just, I suppose in a world of, legal pluralism, a pluralism of normative orders, I suppose there could be 3 models of interaction between normative models. One is kind of hierarchical, the other one is by way of collisions, and then the third one is some sort of dialogic model of interaction. So one way to read the first part of your talk is to say that for certain issues, it's appropriate to, establish hierarchies. There are certain legal orders and decision makers that should prevail. But then on the last slide, it says, you say, right for decisions to be made through open collective deliberation guided by appropriate consultation, which opens it up to the possibility that it's actually a kind of more dialogic interaction across, different normative orders. And so I was wondering whether, there is a tension there or whether I'm just misunderstanding your argument.
Yeah, I guess, first of all, historically, we had forms of legal pluralism between different peoples. You know, we weren't culturally homogenous, so there were processes for taking in peoples and so on. So there's that part of it. The other part of it is that sometimes, and I'm at fault for this as well, when we talk about Indigenous law, it's like one big bundle of wax, right? You know, we can only sort of make the steps and figuring things out on a area by area basis. How we deal with child welfare or child protection is going to be really different than how we deal with water, for instance. And so in looking at what are the different legal issues, what's really important is to look at, from an Indigenous legal perspective, what is the legal issue? And what are the processes by which people are going to legitimately make a decision, inclusively and other legalities that are required in that people are then going to be able to recognize as lawful. In terms of how do we do that between different legal orders, again, it's going to depend on area of law. It's going to depend on the political and the economic and the other kinds of realities that people have to deal with in what it is that they're doing. You know, if we look at the history of Canada and all of the ways that people have been interacting for 400 years on the East Coast and less than that on the West Coast, Indigenous peoples have been pragmatic, very pragmatic in terms of in terms of negotiating, in terms of trying to establish relationships and so on. So there's, I think that there's multiple processes that have gone on, which have created a complex of legal relationships. There's not one way that we can understand all of that. But you're right. I mean, each situation requires that we think about what's going on in this interaction.
Jackie?
Yes, well, Jackie Troy, Director, Indigenous Research here. I just want to say, Val, thank you so much. Everything you've said tonight, I feel applies absolutely to Australia, as I think Teela may have pointed to already. I also want to acknowledge the genius of this law school in bringing you here and the long interactions you've had beginning earlier, I think, with Nicole, and to have Teela and also Brendan Loizou as two of our great legal minds associated with this law school. Brendan embarking on his PhD, maybe Marlikka, who's Nyikina, might be in our audience as well, and no doubt other Indigenous scholars as well. But I'm hoping, and I don't know, I'm going to ask the question, do you think that we have the opportunity here now at Sydney to follow the genius idea of our former Dean of Law, current Dean of Law, to open up an international Indigenous school or centre for Indigenous legal knowledges? I know Teela's very keen on that and as well. So is that something that we can look forward to, do you think, in collaboration with, congratulations, your new finally verified national centre? And yeah, thank you.
I think that that's absolutely a beautiful possibility. And I think that, we need to look at all of there's not going to be one step or even one linear way of getting there. Like how those kinds of things are going to happen is as a result of lots of people doing lots of different work and creating the possibilities through each of the steps that they're taking. We do a fair bit of work, well, whenever we work in partnership with the community, the initial work is about what makes law law, but also what are all of the different ways that people are working, and looking at how can we recognize all of the different engagements and commitments that people have, so that we get past the idea that there's only one way to do things, because that really creates a lot of conflict, especially at the local level. So one of the things that I shared earlier was that we ran a pilot for teaching Indigenous law in 2009. We didn't launch the JID, the Indigenous law degree, until 2018, right? So it took some time. So I'm amazed by the thought and the work that is going on by so many people here. There's a lot of strength.
Thank you, Professor Val. My name is Molly. I'm a Kondamuka person and lawyer working in the space of cultural heritage and environmental law. And I just had a question about your first example relating to the pipeline. And you were sort of discussing how, when applying an Indigenous legal perspective or order to that issue, there might have been an outcome where, they could have agreed to the pipeline with certain conditions, but, there potentially also could have been an outcome where they wouldn't have agreed to it. And I guess, how do you resolve a conflict where the Western legal tradition is sort of saying one thing and Indigenous legal traditions are saying another thing in terms of what should happen, as well as, I guess, taking into account free, prior and informed consent and, veto rights. I guess, how do you sort of resolve that conflict?
Not easily. I wish there was like just a formula that you could go through, but that law is not a formula, and it's case by case, and there are lots of really hard issues that people have to try and figure out together, and together in a way that enables them to understand the decision as legitimate. And so that's a conversation about, like, so what makes law law, and what are the standards of legitimacy that people hold, and how will we live with those differences? Like, that's like, we need to have those conversations locally, as well as on a larger, regional and provincial and national and international scale. And I guess what's really important is that we don't lose that complexity, of what we were saying earlier about the micro in terms of people's lives and what's before people, but all of the ways that that's connected to the larger world. That's another aspect that we have to be able to hold in the hard work of law.
Professor Napoleon, my name is Mary Crock. I'm from Sydney Law School. We stand in awe of what you have achieved. We've been watching it now for years, but it is extraordinary. I'm an administrative lawyer, and I wanted to ask you whether administrative law in Canada has played a role in bringing Indigenous law to the centre of the legal system. Thank you.
So admin law is one of the areas in the Indigenous law degree program. It's one of the areas that students take in their third or fourth year. And it's multi-juridical because the cases are more contemporary times. We don't have admin law historic cases. So it's a way of, there are ways to study the different legal traditions through the contemporary cases. And that's been a really useful way to structure and look at that case in terms of governance and authorities and fairness and everything else, public law and private law and where the lines are. In terms of, how has it, the connection with the administrative law cases and in Indigenous law, I mean, there are things that you can identify and think through, especially if they involve governance or they involve those kinds of decisions, but that hasn't been the avenue for really invigorating Indigenous legal orders. Like one of the questions I think that has to be asked of all of the different ways that people are acting on commitments is, are we changing the relations of power that we're having to deal with, or are we simply perpetuating them? And sometimes, depending on the area of law and how we're engaging with it, I wonder if we're actually making the changes. Admin law is one I have a lot of questions of, so that's a really messy answer. It's just like admin law.
Do we have one more question, one last question, you think?
Thank you so much, Professor Napoleon. I'm Alexandra Gray. I'm from a law school just up the road at UTS. And you mentioned in your talk that in one of your, I think the first case study that you gave us, that you'd sort of distilled the principles for us onto the screen, but you said they could be understood much more deeply actually in the original language of that nation. And so I wondered, in the teaching that you're doing at Vic Law School now, or particularly in the new and expanded and wonderful centre, what scope is there for teaching and learning in languages other than English?
Yeah, so we have a whole Indigenous linguistic program at the law school that I'm looking forward to more collaboration with. And we have one of the courses in the Indigenous law degree program is Kostelish. There's languages and law. That's a combined mandatory course. But there's much more that needs to be done. And I was telling some folks earlier that one of a marvelous Mi'kmaq scholar, her name is Naomi Metallic, has written 2 papers about linguistic ways of teaching, using a linguistic methodology for teaching law and for thinking about law and for learning law. So there are resources that like Naomi's developing, but others are developing that I would like to see more of in the different ways that we're working with Indigenous law. There's no one way to teach Indigenous law or to learn it. So there's more that's needed. And there's a huge variation of perspectives. I mean, I think everybody agrees that language is really important. And it's really important that we think about languages as ways of thinking. But I've also heard Indigenous people, including a Secwepemc leader, say, but if we only had Secwepemc, if we only spoke in Secwepemc, we'd lose half of our people don't understand it. So there's trying to make sure that there's that all of that intellectual life as much as possible is supported and creative, along with everything else that people need. And so it's really lumpy, and there's lots more work to do, and it is important. I worry though sometimes because language can become a currency of power too, and it can play out that way in some situations. And so that's one of the aspects to pay attention to in the work.
Thank you, everyone, for your questions. Thank you for answering them, Professor Napoleon. And now we're just going to wrap up. Marlikka, come up.
Nyajino Nilawamleka, Ngayo Yumarawaraman and Jaida Buruiora. Thank you to the custodians who have cared for this place since the beginning of time. And thank you for the people who choose to care for it today. I actually really like sitting in this room because you can see these gaddy trees here and they're very young, and it inspires me and gives me hope because I think about how big these trees were prior to colonization. I hope that the university protects them and they get to grow that large as well. I'd like to thank Val for coming tonight and sharing her time, but I also want to thank her for everything she's done for Indigenous people. As a young person, following on from her work, she's made it a lot easier for us here in Australia. So I'm very grateful, and I'd like to hand this over to you. I also want to do a shout out to Elijah because he's a very special person and I'm excited to see what your future holds. Last night, I actually had the privilege of sharing a meal with Professor Napoleon and Teela Reid. And we were sitting around the table and Val offered us or suggested to us the thought that she's given us all again tonight. What would our world or our country look like if we placed first laws at the centre? And for me, this was a really big shift in my thinking. For so long, I've been told that we have to see where we will fit in colonial law and where we can fit in without having a conflict to this colonial law. This idea of reimagining our country, it really resonated with me because I got to think about an ungod. An ungod is a sacred spirit that lives in a water hole and it's permanent water. And I think about how valuable that source of life is and how we've just bottled them up, put them through pipes and changed their shape. We need to think about how special these open water sources are to everything that lives around them. I continue to think the what if. What if First Nations people could practice cultural burning and regenerate their country? I've been practicing this on my homelands and I've seen just in a few years, native grasses and ground covers come back. And I think about the amount of poison people have used on my country to control the weeds and things that have invaded us. I think about the Agent Orange that my family was forced to live under. I think of how infidelity and domestic abuse is out of hand in Australia. And I think about how this used to be shared as a community value that we would all work through together. It wouldn't be something that you dealt with in private. I then realized that my imagination was limited by my own lived experience. And I realized how little I knew and how much more we had to invite people in on these conversations. I think about all the voices here tonight that have something to contribute, and you've also contributed your time, so thank you. When Val told me this, I actually went back and started to keep trying to imagine and imagine and imagine, and I pondered it with my husband, and we've now taken this on as a new meditation. And meditation is a really important thing to ensure that our minds are not closed in and limited by what we're living under. Another meditation that was handed down to me from a Nyikina lawman was, before you go to sleep, think to yourself, am I living with pride? Have I got joy from the prideful decisions I am making? Am I making sure that I'm protecting myself, my community, and my country? I think that we all owe it to ourselves to make sure that we are prideful people, doing this, stepping lightly and positively. So I'm very grateful for this opportunity tonight, And I'm very grateful that we also have Teela Reid here moving a lot of this change, and to Simon Bronnett, who was a major force, and I'll always think of him looking at those gaddy trees. I'm really excited to know that we are looking at creating a new story here at Sydney Uni with a new faces and a new team to create a new history for Australia, because we can't let it continue this way. So thank you, everyone.
Thank you, Marlikka, for giving the thanks. Thank you, Brendan, for facilitating the Q&A. Thank you, Teela, for giving the opening, and Rita for the introductions. But let us all again thank Professor Napoleon. Thank you once again to all of you. That concludes the proceedings for this evening. Please come next year, and please come to all of our other events. Good night.